So,
Oh, all right.
yeah.
All right, welcome everybody to another episode of Legal Tech Week. It is March 15th, 2024. Is today the Ides of March? Is that?
The Ides of March, it is.
Today's the Ides of March. And this is the show where we talk about the top stories in legal tech from the past week with our panel of expert legal tech bloggers and journalists. I am Bob Ambrogi. I have a blog called Law Sites and a podcast called Law Next. And our panel today, Victor, since you've got something in your mouth, I'll pick on you first.
That's fair. My name is Victor Lee. I am Assistant Managing Editor for the ABA Journal, handling business of law and technology.
All right. Joe.
Joe Patrice from Above the Law and Thinking Like a Lawyer podcast. And I am happy to be here as always on the Ides. I'm keeping a look over my shoulder, but no one's trying to stab me yet.
But you did mention you're alone in the house. Wait till somebody comes home.
Yeah.
And Steve.
Steve Embry here. I write the blog Tech Law Crossroads, and I am also watching that back on the Ides of March.
And last but not least, Niki.
Niki Black. I'm the head of SME and external education at LawPay and MyCase, and well, all the legal tech companies on the AffiniPay side of things. And I write legal tech columns for ABA Journal, Above the Law, and the Daily Record. And I also oversee industry and benchmark reports that I write for the for AffiniPay. And I don't think I'm going to get stabbed. I'm feeling pretty good about it. So.
All right, we'll let you know if we see anybody sneaking up on you. I don't know where to start today. We were just talking before we started the recording about the fact that the Supreme Court today issued a ruling on government officials' use of social media platforms, and at least one of us has actually scanned the ruling. I've read a couple of stories about it. I haven't actually had a chance to read it yet, but it seemed like an interesting approach. And as Steve Embry just said before we started, perhaps the most interesting thing is that it was a unanimous opinion from the court. But I don't know, Joe, you said you looked at it a little bit. You think, is there anything kind of comment notable wise about it?
Yeah, well, I mean, not hugely. I took a look at it just to see if there was going to be something really wacky and interesting about it, and it's not really. Look, this has been a long-standing issue, the question of whether or not people who are politicians can block people who they don't like. You have certain obligations as a government official to, be open to the public. And where do you draw that line? And the Supreme Court decided that there is a line, and it kind of hangs on whether or not your account is speaking for the state. And that seemed entirely reasonable. I don't know how functional it's all going to be, because I think there's probably going to be blurring a lot, but it seems like they did the best they did the most logical thing they could, I thought. The
something that confused me just reading the stories about it was that if they are using their official government account, it seemed that wasn't in and of itself enough. They also had to be talking about official government business. They could be on their official government account and talking about their kids' Little League game, and that's somehow a different thing. And does it come down to like a sort of a tweet by tweet analysis or what?
And that was the dumb part of it, because it does seem like they want it to be a tweet by tweet analysis. Now it's like, but you block accounts forever. Like, I guess it maybe you can mute somebody in a conversation, but blocking is something that, like, if you block them, then they won't know whether the tweet is about a baseball game or the whole thing. So I really thought that part of it was kind of dumb. I thought that the crux, though, that if you're in a position where your account speaks for the government and for official business, then you can't block people, made sense. But yeah, you're right. They walked themselves into a bit of a corner with the tweet by tweet analysis kind of argument.
That's what it looked like to me, but I literally only read like a summary. So, but what I read seemed to indicate, and correct me if I'm wrong about this, because I didn't read the decision, but it said that if the tweet was used to make an official announcement that wasn't announced elsewhere, or some sort of, but if it was sort of reiterating something that had already been sent through some other public channel, then that it didn't qualify. But if it was used as the sole platform to make certain types of announcements, then that was what you hung your hat on. But I did not read the opinion. It was a summary, and I don't know if that person got the summary right. It was not ChatGPT.
When I first saw it, I thought it must involve former President Trump and his efforts to block people from some of the things that he had tweeted, but it did not. I mean, that case was mooted when he lost the election, and this was like some school board members in California or something like that. That I was surprised at that a little bit by that. I wouldn't have thought that hearing about it.
Yeah, I mean, just reading about it now, it seems like it's very. So, like, one thing they said is that the official must have some authority to communicate with residents on behalf of the government. So, if I think the hypothetical that they posit is that if someone's complaining about food or health or health conditions at a restaurant, if this person is the commissioner in charge of health and restaurants and whatnot, then this would arise. But if this person's just in the government but doesn't have any say over that, so it seems like it's a very, like, it's almost like they're maybe trying to trying to be a little too thorough with things, trying to narrow things a little bit too much, and it just seems like it's creating more questions than answers. I mean, just looking over it now, I'm kind of confused about when something would count and when it wouldn't count.
Yeah.
Sounds like a boon. Sounds like a.
I don't know how you feel about it. Dennis just asked if we're okay with someone using Otter AI to create a transcription of everything that's going on. Someone's using that. I don't know.
They do it every week. They've been here.
Yeah, I just thought I'd throw that out there and let you
They've
weigh
been
in.
doing it on a regular basis. Yeah.
As long as it pertains.
As
long as it pertains to official business of the roundtable, then it will be acceptable. Strays away from that, then you'll have to delete it.
But it's going to include comments and screenshots and other things. I'm not sure. I don't know.
Yeah. I use my Fireflies AI in every meeting I go into, and it's always, as I've mentioned probably before on here, and it's really kind of funny because it shows up even when I don't show up for the meetings. And people sometimes think it's me in the meeting when I'm not there, or they have no idea what it is, and they start talking about me. With due deference to some of the PR people in the audience out there, there's been I sometimes get this little bit of a chatter in the transcript that I get from Fireflies from before I join the call, and you get, like, the executive is saying to the PR person, who the hell is this guy and what are we talking about, and and it all comes out in the transcript. So be cautious of my Fireflies, or don't be cautious of my Fireflies. All the better. All right. Well, maybe we should do the obligatory get out of the way. Yes, another lawyer hallucinated cases this week and got in trouble for it. I mean, it's like we can have a weekly spot around lawyers hallucinating cases. This was a lawyer in Florida who actually had probably the most severe consequence so far, in that he got suspended from practice for a year. Now, he was suspended. It was a federal district court case, so he's suspended only from practicing in that federal district court. Doesn't implicate his ability to practice in state courts or if there was any other courts he's admitted in. But you have to imagine this is going to get referred over to the state bar authorities as well, and sometimes there can be reciprocal discipline for something like this. It's weirdly, it's a kind of a weirdly written decision in that it's apparent. It seems that he used generative AI to come up with these fake cases, but it was a case. It was a situation where there were some made up cases that didn't exist, and the opposing counsel asked him about them, and he never responded to opposing counsel, I guess. The opposing counsel filed a motion for sanctions or something like that. The court referred it to its own. It has its own disciplinary committee or grievance committee or something like that, which reviewed the matter, called the guy on the phone and asked him about it. And he said, "Oh, I don't know. I used Westlaw or Fastcase, or maybe I used generative AI. I don't know." And that was about it. And they asked him to give a written response, and he gave a written response in which he never addressed the made up cases. And apparently showed, as this committee found, he failed to understand the consequences of why this was even important. So they recommended he be suspended, and that was sent to the judge, the chief judge, or actually one of the judges of the district court, and they issued an order suspending him. So there you have it.
And I read the opinion of the grievance committee, and this fictitious citations wasn't all. I mean, this guy was apparently a pretty bad actor. He'd been harassing the opposing counsel and threatening RICO claims if he didn't settle, and he filed several motions to try to get the case removed. I don't know why he, wanted to be in federal court, but in any event, it was. I mean, it just sort of reading between the lines, it sort of sounded like the judge and the grievance committee had just had enough of this guy. Not the least of which was he cited fictitious cases, but he had apparently done a lot of other bad stuff too.
But that seems to be the case. I mean, in a couple of these cases where, the lawyers are clearly screwing up on multiple levels,
Right.
Right. And it's bad lawyering all around, and the fictitious cases ends up just being a symptom of that in a way.
Yeah, I mean, if you're a bad lawyer, you're not going to become a good lawyer because of ChatGPT. I mean, if anything, it's going to make you an even worse lawyer, or it's going to enable whatever problems you already had, or whatever shortcomings that were already present. I mean, yeah, clearly this guy is, and plus, I mean, just looking at from the Florida bar point of view, even if that other stuff hadn't happened, it seems like they take tech competence pretty seriously. I mean, they're one of the ones that's really out there in the forefront. Like that, I think they were one of the first ones to adopt that. To adopt the requirement in their ethical rules for the lawyers. So I can see why they would be like, okay, you know what? If you're going to use this tech, you should really know what the consequences are and what could potentially happen if you misuse it. So I mean, I'm sure, but yeah, like exacerbating factors were probably also a factor in this case.
Doesn't Florida have a mandatory technology CLE requirement? Isn't it one of the states? Yeah.
Florida is one of the 2 states that does.
Yeah, that's what I thought.
The other one is either it's south or north. I think it's south.
Yes,
Carolina.
It's one of the Carolinas. Yeah, that's what I was.
New York has a cybersecurity one, which is new, which is an interesting twist on it.
Right. Well, I should have had it. I don't have it in front of me, but Doug Austin had a kind of a funny post about this latest one, kind of talking about doing the math on when we're going to see an end to this, and his calculations came up with it basically never. This is going to keep happening. So, unfortunately, that seems to be the case right now.
I think the solution would be what one attorney came up and told me that he did when using public, consumer-facing AIs, is he would put all the output into another AI and say, is this correct, and fact check it. Like, I feel like we should at least be telling him, all right, well, you shouldn't be using it for this, but if you're going to, at least, ask Gemini if ChatGPT did it right. See what happens. That's the solution.
Yeah. Don't ask the same generative AI like that. That was the first case, right?
All right, he went right back to ChatGPT and said, give me the cases. And it said, all right, here you go.
I thought you said these were real.
Well, this is where, Stephanie's not here, but I'll role play as her here, because she's been talking about the hallucination in Inception. The new problem, though, is that if the mistake is being generated because ChatGPT or whatever has found some blog post where someone is wrong, and they cite it and say, oh yeah, no, Professor so-and-so says this, and it's incorrect. Then when you ask Gemini, it's going to find the same thing and go, you know what? Actually, yeah, no, this is. So it doesn't necessarily fix the problem just to go to other things. If we reach the point of hallucination inception, where the hallucinations then are reprinted in other media that the thing uses to figure out the answer.
That's a good point. I was, just to be clear, saying that in jest. I mean,
yeah, obviously.
Yeah, no, that's a good point. We're getting into this weird area, like weird situation now as AI proliferates.
Well, did we talk? We might have talked about this last week. The case where the lawyer filed hallucinated cases, but it was the lawyer had found a blog post. The lawyer didn't go to ChatGPT. The lawyer had found a blog post that appeared to be right on point to what the lawyer was arguing, and just pulled the stuff out of the blog post. But
Yeah,
it turned out the
but they
blog
tell you
post
you
was
shouldn't cite
generated by
that.
Chat.
But they
I
tell
hope
you
it wasn't law
they,
sites.
they tell you, yeah, they tell you you shouldn't cite that as a primary source anyway. I mean, like you shouldn't be citing blog posts. It's like citing Wikipedia. It's like, I mean, no,
No, but the
that's,
blog
yeah.
post had cases in it, and he pulled the
Yeah, no,
cases
but
out
then,
of the
but then you
blog
check,
post.
but then you check the citations, right?
Yeah,
Like on
well,
Westlaw.
right.
So.
I
Then
agree.
you actually read the cases.
I mean, you shouldn't be citing blogs in any scenario unless it's about the law, obviously. But otherwise, you shouldn't be doing that. And you should definitely cite check me because, I mean, I'm probably right, but you don't know.
I don't know. I beg to differ. I think Law Sites is another blog you should be citing.
Okay, there. All right, fair enough.
We've already all been cited. I've actually been cited in like law review articles and stuff. That's the weirdest thing. To think that anybody would think that that's authoritative.
Well, Donald Trump cited me in a motion to like get the
right.
judge kicked off. Yeah.
Yeah. All right. That outdoes the rest of us.
Yeah, you win.
No, but which of his many lawyers was it?
I think it was the New York thing. So it was Alina and what's his name? I'm blanking. Blanche, I guess.
Yeah. We've had a little discussion going on in the chat here based on our Otter AI being here about automated transcription of meetings. And as it happens, we actually have a story this week related to automated transcription, not of meetings, but of court proceedings, I guess. Victor, that was yours, right? You want to talk about that?
Yeah, so I did a podcast that went up this week about talking to the co-founder of Scribe AI, Carl Seelbach. He was actually got him from the thing at Tech Show, the Startup Valley. I couldn't remember. Yeah, the thing with Bob and like they call people up and
and Steve's there sometimes.
Yeah, and like for some reason they'll play music in between every single person.
The thing, the
music was good.
something.
Did we talk about the music?
Yeah,
the music was good this year.
Yeah, it was weird. It was like first it would go like Imagine Dragons, and it would be like Rolling Stones. I'm like, this is weird. But anyway, yeah. So yeah, I talked to him about because Scribe is a AI. It's an AI tool that allows for automated transcription of proceedings. They're mainly doing depositions right now, but his hope is obviously that it becomes more widespread, and they're using court proceedings and trials and hearings and whatnot. And obviously that raises a lot of issues, as to accuracy. It raises a lot of issues as to cost, as to convenience, but also just the court reporters organization, the various organizations throughout the country and throughout the various states, they're very protective of the turf, and they're very very anti this technology in general. And they've been very out in the forefront. And we talked about this a little bit, but not as much. But like they've been very much out in the forefront to try to talk about the dangers of the technology and how transcription tools cannot possibly be as accurate as humans. They can't capture the same types of inflections, same types of emotions, same types of context and that kind of stuff. And I mean, understandably so. Like like these people go to school for how many years to learn how to do shorthand. I mean, it's not easy. I sure as hell don't know how to use that machine. I sure as hell don't know how to read it. They're heavily regulated, and they have their model where it's like they come up with a transcript. They make a very nice living off of it because it's very expensive to get those transcripts, especially during the course of a trial. Like I think the last trial I did a long time ago, we paid like an arm and a leg to get those transcripts, like to the daily copy of the transcripts that we would get like in the following morning. So even then, so we had to wait like whatever it was, like 7-8 hours before we got to see what happened the previous day. So if there's something that's more convenient and more accurate that can come along and much more affordable to come along, I can see why they would be worried about their turf. But one thing that kind of struck me was that like this could be a good thing. This could be a good kind of tool to use along with humans. It's not necessarily something that could replace them. It's something that you could use in conjunction with the human court reporters to make both of them better. Because look, even human court reporters, like they miss one thing or they zone out one little minute of a hearing or of a summation or of a whatever, then you can't trust the record anymore. So it's a high stakes job. It seems like any kind of thing that could help them do their jobs better would be welcome. But obviously, from covering this for a long time, we know that that's not necessarily the case. So, but it was an interesting conversation, and I encourage people to go to check it out.
I talked to that guy too, and one of the interesting things that he told me, because I asked him, I said, well, like, how do you create the transcript? You don't have it. And he said, well, the official record is not the written, it's the video. So the video is what is official. So if you want to, I guess, impeach a witness, you go back to the video and you don't go to what was written down, which I thought was kind of an interesting approach. I guess it's valid. I don't know, but anyway, that gets you over not having a court reporter. According to him, I think you don't have that gets you over not having a court reporter produce an official transcript. The official transcript is the video record. That's what he told me. I don't know if that's true or not.
No. He told me that too, and also, because look, with transcript, I don't know. I mean, we've for trial lawyers and whatnot, you've seen them. Like they don't put in there like they don't necessarily put in there. Witness gesticulates with his hands, or witness, does this. Sometimes you might be able to point out, like, oh, let the record reflect that the witness is laughing, or let the record reflect the witness is like, giving me the finger or whatnot, but if it doesn't get pointed out, or if it doesn't get talked about in that moment, then just very often it'll just pass, and then you don't see the actual context of it. So very often you're going off transcripts that don't have that kind of context anyway. So, so that was something I was kind of concerned about. I had a question about it. Like, well, what's the big deal about context? Because very often these transcripts, they don't have that kind of context anyway.
I think the video would be really useful as a litigator with the transcript in conjunction with it, because you can, I think, reviewing the video, maybe you can get like a sense of the witnesses tell, like every time this person lies. I didn't notice it when I was crossing him or her, but every time they lie, they, scratch their nose or something. And so maybe it could give you additional context. Right? But like, we're all scratching our noses now, we're a bunch of liars. But I think in some ways that might be kind of an interesting proposition for a trial attorney, especially as long as you knew exactly when, because it'd be a pain to go through the whole video and try and find that exact spot. But if the transcript could tell you exactly where it was in relation to, give you the, I forget what you call it, but the exact point in the video to go to.
Yeah, I think this guy's system, I think it does that. I know Lit Software has a system that does that. It links the two up sort of automatically. So you used to have to pay extra for that linkage, I think.
There's a couple of different deposition software applications, not software, but hosting sites, like Steno is one, and
right.
A couple of others out there, I forget, but that they include the real-time transcription as part of the service. And you can still have a court reporter if you want to have a court reporter, but it's giving you, as people are speaking, it's giving you the audio transcription, the text transcription, audio to text transcription that's searchable. So, you could be in the middle of a deposition, a video online deposition, but you can go back and say, instead of having to ask the court reporter to go back and repeat what the witness said 10 minutes ago or something, you can actually go back and search the transcript of it real time, basically, and get what they said. And if you've ever watched those or used those, it's really pretty remarkable how accurate they are. Maybe they're not as accurate as a court reporter, but like Victor said, court reporters have off days too, and that's one of the reasons lawyers in a case will go back and review the transcript after they get it from the court reporter and look for mistakes that they found or issues or anything like that. So I don't know. It seems to me that this is an enormous opportunity to significantly reduce the cost of depositions, and also, it becomes an access to justice issue in courts when people have to start paying for to get copies of court reporter transcripts. It's a lot of money to have to get those things.
And as I understand it, there's a shortage of court reporters as well. I also asked the guy, you probably did too, Victor. I said, well, like, do you have to, the parties have to agree to use your service? And he said, no, I mean, in most states, there's not a requirement that the transcript be taken by a certified court reporter, I guess, which kind of surprised me.
Yeah, I
I
was
never
surprised by
looked
that
into
too.
it.
Yeah.
Yeah.
I think it's just that's the way it was always done. I think that's the way it's always been done. And you know, this is very much you know, the legal industry is very much one that goes by things that have been done before. And you know, I think like that's always been the gold standard, and so that's what people go with, and that's what they're familiar with.
Right. And there are I mean, in Massachusetts anyway, in the courts, there are often the recording is actually often the official record of the proceeding. They'll literally a tape recording or well, I'm sure they're using a digital recording, but in audio, primarily an audio recording, especially in the lower courts in Massachusetts, is considered the official record of the case, even not even a transcript.
In town courts in New York, where you often don't have necessarily lawyers as judges, there aren't even transcripts. There's no recording. There's no nothing. At least there didn't used to be when I was a public defender. It was just a free for all. Like there was no idea what happened. You just went out there and did your job.
Yeah.
And the judges were like, it was like the wild, wild west because they weren't always lawyers and there was no recording. So sometimes they did some pretty ridiculous things. But
yeah, I think one of my first arraignments that I did. So I'm like reading the file as the person's being arraigned, and so I have no idea what's going on. So I'm like, the people, and I can see the reporters typing every single and I was like, stop there. Stop there.
my very first, I was like on my first night, I was like thrown in feet first, and the judge sentenced the guy on a B misdemeanor. I just showed up for sentencing. That was the case that had been handed off to me to 90 days shock probation. And so I went and I like wrote it down and handed it to the felony attorneys that had the guy in the same case. And one of them came to me and said, just so you know, 60 days shock probation is the cap. So that was an illegal sentence. I was like, oh, like I went and told all the lawyers about it. Like I was really proud that I was telling him what happened. And the judge knew that it was illegal. He knew I didn't know. So it's like, that's the worst when there were very few judges that ever did that, but that's a whole different issue. But that's the worst when a judge does that just because they know you don't know what you're doing. But
what about this issue raised by Laura in the chat? I mean, this is you know, we've been talking a lot about deep fakes on this show over the last few weeks. So how do you know that a video recording of a court proceeding or a deposition hasn't somehow been altered or faked or whatever else?
really good question.
I guess you have to rely upon the credibility of the service that's taking it.
Yeah.
Which, you know, I don't know that much about them, but you know, I mean, they sounded good, but who knows? You know?
Yeah.
Well, and everybody can spot, there's a price. Everyone's got a price, right?
I mean,
So
it's not even
really
deep faking, but I use this platform for recording my podcast, my other podcast, and it's you know, you can go once you've recorded, and it records video and audio. But after the podcast, you can go and edit the podcast. You can edit the video simply by editing the text, and it's like super cool. But you get the full text transcription of the podcast. And you can go in and delete a sentence, and it's gone out of the video, and that's all there is to it. You don't have to do any video editing or anything else. It's pretty cool. So those kinds of tools are cool, but potentially scary. Well, I guess speaking of deleting text, that could be a good transition, Niki, to the story that you have this week about maybe not undeleting, but unredacting text.
Yeah, I thought it was really interesting. It's almost not even a story and more of a commentary. It was from Schneier on security. He's a guy that is a security expert who he's the one that came up with like the security tango, describing the requirement at airports to do all these random things just because, and how it's just a song and dance and doesn't actually protect us. But typically he will post about security. And I guess in a way this is about security. It's especially if you're talking like FOIA requests versus litigation. But he basically is talking about how AI can be used. I probably should have led with this. AI can be used to redact, LLMs can be used to unredact redacted documents. And then it linked to a tweet about it, a Twitter post, an X post, where someone was just showing how they were using an LLM to do just that, and showed an example of a redacted document, and then how the LLM was able to, with a good degree of accuracy, predict what a lot of the different redactions were based upon the context and the length of the redaction. You know, how long is this word or this phrase? And you know, it's looks like it's sort of a use case in its infancy, but it has really significant implications, I think, for litigation. You know, if you get redacted documents, and then you can figure out exactly what it says, I mean, that has some pretty, you know, the judges allowed them to redact certain information due to privilege or whatever, and you can accurately predict what it says. I mean, that's a pretty big issue, and that potentially impacts attorney-client confidentiality and all these other issues. And then for FOIA requests, I mean, think about the fact that you can, the government redacts all this like top secret information and or classified or whatever the case may be, and you can just get a FOIA request and figure out what it says. So I thought it was a really interesting it's a technology that clearly is not perfected, but it has some pretty drastic implications for in a number of different contexts. So I thought it was worth highlighting.
We've talked.
I thought it was kind of scary too when I read it. I mean, it's got all kinds of ethical implications, and then you have to get into the accuracy, and I mean, it's just what a ball of something.
We've talked before about how so many of the redaction fiascos that have happened over the years where lawyers thought they had redacted documents and hadn't properly redacted documents. And the easy way to test that is always to simply take the PDF and do a select all, Control A, whatever it is, and then copy and paste it into another document. And if they haven't properly redacted it, you can read everything that should have been redacted. But this is a whole different thing, because it's not literally unredacting. It's using, you know, the LLM to try and predict what the words would be there. And in that example, in his that he points to an example on Twitter or on X, what somebody else had posted. And they was an email, I think, from Elon Musk where he tried to, that had been produced I guess in some litigation or something, that had been redacted in some ways. And so he was trying to predict what it was that Musk had said, and he came up with an answer. But then he posted several more images of like a whole string of here are all possible answers that could have fit within that word pattern and whatever else. So it's not very accurate at this point. I mean, it's really just kind of guessing at what the words mean. So it's not precise. But, you know, again, as you say, Niki, we're, you know, who knows how it'll be in a couple of years or whatever,
or even quicker, because it's moving so fast.
Yeah.
You know?
Well, I think the concern there is going to be that if it gets to a point where it's pretty good at it, it's going to cause a bunch of bad faith redactions where people over redact because they have to over redact to kind of trick the AI. You're going to get a lot of bad faith fights about redactions. It's going to be really obnoxious, and it's really great that I don't currently practice.
We're going to start writing emails in very unintelligible manner, so that it's very unpredictable. People can't figure out what they're saying.
In fairness, half these people write unintelligible emails anyway, is my experience. So,
I mean, just thinking about it, though, I mean, I don't know that it's that far away from being able to do that pretty accurately. I mean, you take the Elon Musk email. If you have enough emails from him that you provide to the tool, so it understands or recognizes the pattern of how he speaks or writes, I guess is the better one. It wouldn't seem to me to be very far for it to produce a pretty accurate prediction of what the redacted material was.
Unless it's a name or, I don't know, something unique that necessarily wouldn't have necessarily shown up in patterns, it seems like that would be pretty difficult to predict. I don't know.
Well,
What do I know?
what if like he was saying, if you created an LLM specific for that and you fed it the right data, not just all the emails you can find that, this particular person wrote, but also all the news articles about the specific topic, that have come down, or the Wikipedia articles. I don't know about all the people that are involved in this. And if you gave it information specific to what's being discussed, I bet that's going to make it a lot easier for it to predict, who he was talking about. I think that's the email, if I recall, where he's trying to say who's going to win the AI war or something. I remember reading other articles about that email that was redacted.
Yeah.
But
But still, it'd be awfully hard to ever be certain. I mean, if somebody says, okay, I gave the classified documents to redacted, and this was a well enough known situation where there were, names out there being talked about who we might have given the classified documents to, but we still don't know. So we're trying to get at who it was actually by unredacting this email. Well, it's still going to just be a guess at that point.
yeah, but think about it this way.
Yes,
So if you've got-
yes. Go ahead,
if
Niki.
you
I'm
got
sorry.
someone on the stand and you have this unredacted email, like that to a certain degree of accuracy is correct, and you have like 15 different things in this, or different sections of emails or something that have been predictably unredacted, then you could start with the more innocuous ones and, cross-examine them and see if you could sort of dance around and judge by the person's responses whether maybe what you're suggesting is correct. Isn't it true that this was really about X, and try and figure out what their perspective was. When you really get to the important one, which is who was this person's name, maybe by then you'll have gotten a sense of their response, which is correct. And, how do they react when you are really getting at the particular issue that you think it is, like the particular answer. And maybe then, even though you're not going to know for sure, you're going to have a better sense of where that puzzle piece fits into your overall litigation and what you're going to do next with your cross-examination questions or whatever.
Yes. I mean, the opportunity for mischief, you don't know 100% if it's correct, but even if it's 75% chance it's correct, or 50%, I mean, you begin to follow up on the threads, and you can pretty quickly figure it out, I would think, how, it was correct or not. So think about it in settlement negotiations. If you were you were able to unredact the discussions on the other side about what they would pay or wouldn't pay, that would it could really change things.
Makes you think that some jurisdictions should pass comprehensive legislation regulating AI.
If only we knew how it worked.
What an interesting, what an interesting idea.
like was there one this week?
So the European Union doing what it does best, which is diving into cutting edge technology regulation before the US can, follows up on hot on the heels of their success at GDPR. They have decided to have a AI Act that will regulate the uses and development of AI, which, they're there before we are, which is great for them. What can I tell you about it? Let me get my notes here, because there we go. So the way in which they go about doing this, to keep this straight. So they have a few tiers of how they deal with AI. The first tier is they prohibited certain uses. So AI that does social scoring, like deciding who's a good and bad citizen, predictive policing, stuff that tries to gauge your emotions at work. Those sorts of uses are prohibited. Facial recognition is included in that too, although there is a law enforcement workaround for missing persons and stuff like that, though theoretically law enforcement has to go to a court and get authorization if they want to use this. So those are banned theoretically. And then there's a high risk tier where certain uses of AI are considered kind of suspect and they will be closely monitored. So you can still use AI for infrastructure, like utilities. You can use it in some education and employment and healthcare and banking. All of those, if you're going to use it in those, though, they have to be super accurate. They have to be able to produce upon request proof of how the thing is making its decisions. There are risk assessments. They need to have human oversight, yada, yada, yada. If there are deep fakes being made, they must be disclosed. And the weirdest one I thought was that all the people making these things have to be able to disclose all of what they trained on, which, I mean, obviously we know that that's a thing that can be done. I don't know what happens with places that have already done their training, but who knows? So that's the framework now. That's the opening bid, let's put it, the framework for how to regulate AI. And in about, I don't know, 10, 15 years, that we might have a functional House of Representatives and we could do something like that on our own. But until that moment, Europe's kind of guiding the way. So what do we think about this?
What do you mean we will have a functional House of Representatives? I mean,
No,
they
we'll
passed.
I
said maybe.
They passed the TikTok ban. I mean,
That's right.
How more functional can you get?
No, we'll still be trying to impeach Joe Biden at that point.
Yeah.
They
I
can't-
did wonder if we should talk about the TikTok thing today, because there's an interesting, not to go off on a separate thing, but just since you mentioned it, there is kind of an interesting legal tech side angle, to the extent that the only justification anybody has for this blatantly unconstitutional bid that they're making is, well, we can't let companies, even a company in China, because of national security, have access to, user data. And if that's going to be the standard, I feel there could be a lot of legal technology use cases where important data exists that questionable actors have invested in. I don't know.
Although
Anyway.
it does strike me as a bit ironic that you have a Chinese company that's in one of the most regulated jurisdictions in the world for arguing free speech in the United States. They have a right to do it, so I can't fault them for that. I just think it's kind of ironic.
Well, you got to know your surroundings, right? What was the thing in Batman? You got to know your surroundings. Yeah. So to go back to the EU thing, I mean, I remember when they first came out with this proposal a few months ago. I think we talked about it on the show. It seems like a pretty reasonable guideline. I like framework. I mean, obviously, I haven't studied it that closely, and I'm sure the devil will be in the details. But it seems pretty well thought out, pretty well reasoned. I mean, kind of touches on some of the things that we've been talking about, the dangers of like social scoring and like the biorhythmic activity and whatnot. And like the whole kind I like the kind of sliding scale of sort of like, well, these are the things that are like absolutely banned. These are things that could be risky, but maybe need to be regulated a little bit, and then just general things that people use. So obviously, we'll see how it shakes out, but yeah, it definitely seems like it could be a pretty reasonable guideline or framework for us if we ever, like Joe said, get our acts in gear.
I
That's
think
why it's
that-
worth talking. Go ahead.
I was going to say, I think the way that we could advise our own representatives is they can just watch Black Mirror. And if it's in a Black Mirror episode, then it's banned. Like, could this potentially be a Black Mirror episode? Then it's banned. And so maybe they can just sort of coalesce around that concept. And because pretty much everything they've got in the banned EU was a Black Mirror episode. So I feel like that's a reasonable place.
And I was going to say that's how the EU thing is related to the TikTok thing, because one is reasonable and one is completely not reasonable at all. And the other, it's so typical of how legislation gets made in the United States, where it's always a knee-jerk reaction to some groundless thing that somebody's afraid of, without thinking it through on a broader policy level. I mean, if we want to start worrying about what data companies are collecting from users of their applications or software or whatever else, TikTok isn't the biggest problem here, and you know, Congress should be thinking about it on a whole other level. You know, it's just symptomatic of the dysfunction of our Congress, I think.
I saw a chart
Yeah.
on TikTok. I clearly have no idea if it was legitimate, but it had like TikTok in the middle of, in terms of data collection with like Facebook and Google at the very top. I have no idea whether it was accurate, but I was convinced. So I'm clearly the problem. This is why they're banning TikTok.
I mean, the whole thing is kind of weird because you have people like Donald Trump who you would think would be supportive of the ban. He doesn't. He thinks it's a bad idea, and then you have Joe Biden, who you would think, well, he would oppose doing something like this, and he's ready to sign. I mean, it's. And then you had all these Democrats move over to the Republican side on the vote. I mean, it's kind of very weird.
No, Trump was for it, and then he was against it, and I think in the interim he met with one of the big executives for TikTok. So you know, not to make any accusations, but no, I think I saw someone posted. I mean, maybe it was on TikTok. I don't know, but yeah, I think that Steve Mnuchin and some people were trying to put together a conglomerate to buy TikTok. And so it's like, would I rather have my data go to Steve Mnuchin or to the CCP? I'm like, I don't know.
That was exactly what I was going to cite. I saw the same thing on what the artist formerly known as Twitter. Somebody put it there, and it was kind of chilling. It basically is we're going to utilize everyone's freak out over China, who probably has very few connections to this Chinese business, just because it happens to be there. And we're going to force them to divest, and so they can be bought up by the next Rupert Murdochs of the world, which seems way more problematic from to the extent we believe it's a disinformation vector. Anyway.
Well, and one thing I would note from my own experience on that app is I have noticed this happening significantly more in the last few months. It used to be a very good algorithm that would serve me up whatever I thought was interesting. There are certain topics that are political topics that I won't go into now that I'm not interested in hearing about. And I actually go and I click, do not want to see this again. I'm not interested. Do not want to see this again. And it keeps serving them up to me. And they're very hot political topics that are.
And it was just like, why Taiwan should be part of China. It's so weird.
No, but it is, I think, very clearly, and I'm also getting a lot of super feminist ones, which I'm a feminist and I'm already sort of on that side of TikTok, but my algorithm has changed and it's not based on what I'm watching anymore. And so I do think that, do you guys think, let me ask you this, I think, but you agree that there might be something that we're not aware of that's happening on the back end, like between the AT&T breach that we were talking about before we got online, the AT&T going offline, whether that was a cyber attack or not, that was preceded by discussions on the floor of Congress, from like the Intelligence Committee, with some serious predictions that China was going to do something significant in terms of a cyber attack in the very near future. And then almost all of AT&T went offline, like all the cell phones. I think that was actually a feeler to show what they could do. And then I wonder if there might be some other evidence that they have available that we don't see, like intelligence, that indicates that there's something significant happening, and that maybe there actually is something happening, and this isn't just a knee-jerk reaction attack. But I don't know what you guys think about that, but I feel that might actually be a plausible possibility. No, just me?
I don't know. I mean, I maybe, but I mean, also like, and I kind of said it in jest in the chat, but the rage is the point, like to get you mad, to make you angry, and it's just, you know, I guess if that's one of the ways to make you angry, then they succeeded. I mean, because it's happened to me too, where like on YouTube, I'll say I don't want to see any more Trump campaign ads. I don't want to see any more commercials for gold bars or whatnot. But then after a few months, they come again. And so yeah, I mean, maybe that's just part of it. They're like, okay, well, we can anger you by reinforcing what you already believe in, or we can also anger you by doing something that you clearly don't want us to do. So.
I think these algorithms are whacked. I just often don't understand at all how I get served up some of the stuff I get served up. And I still want somebody to explain to me why it is that when my wife says she's going to shop for shoes online, I suddenly start getting served up ads for shoes on my browser. That's what I can't figure out.
It is wild how that happens. Yeah. I mean, I assume it's a proximity, because it's not like they're listening, but they do know that you're near another device and so on. So, but yeah, it is wild.
listening.
And
I think they're listening.
it makes Christmas shopping terrible, right? Which I don't know if anyone else has experienced this. No, seriously, like when I had a bunch of family here, and you start having the problem of the older kids being like, I actually would really like this because it's showing up in their feed. And I'm like, of course it is, because I just got you the. Yeah, like it's a problem.
Yeah.
They should turn that off during the holidays because it's a real problem.
Yeah. All right. Actually, I forgot to talk about the story I was going to talk about, which was the case law access project. Part of the reason we didn't meet here last Friday was I was at this celebration, I guess, of the freeing from all restrictions of the case law collection created through the Case Law Access Project, which was this thing at Harvard. That was originally started as a
La-ti-da, Harvard.
Well, I mean, the project was partly because Harvard had the cases. I think that's kind of in part how it ended up at Harvard. But what's interesting about it, I mean, this started way back in 2015 when Ravel Law was the thing. Anybody remember Ravel Law? It was a legal research startup. And Daniel Lewis and Nick Reed, who were the co-founders of that, realized when they started, they thought it'd be easy to get digital cases. And then they realized it's not so easy to get digital cases. So apparently they said, well, maybe we can get somebody to digitize them for us. And around that time, they ran into Jonathan Zittrain somewhere from Harvard, and he was looking to do some digitization work, and they kind of got their minds together and said, well, we can put up the money if you guys can do the work. And over the course of 3 years, I mean, they literally sliced up all the law books at Harvard Law and created this massive digital database of case law. But the quid pro quo for Ravel putting up the money for that was that Ravel would control the commercial use of all that data until March 1st, 2024, as it happens. And then, of course, Ravel got acquired by LexisNexis, and so LexisNexis became the commercial licensor of that data. It could be used for free, but it couldn't be used commercially. So that all those commercial restrictions have now been lifted, which means any vendor can go in. I mean, any legal tech startup would come along. I know we've got the Describe. I think the Describe AI guys are in the chat. If I don't know if they're using any of that, but you can go in and just download in bulk all of this data and use it. So it's a pretty cool thing for access to law, and it's all sorts of things you can. I mean, it's some of the projects they've already developed just over the years are like the historical graphing of you can see when did certain terminology first start getting used in court decisions or stop getting used in court decisions, or that sort of thing. It's pretty interesting. So that was all interesting. And then what I actually wrote about was a little bit different, only because as I was leaving that and realizing there was this whole big access to justice thing going on in Cambridge, like less than a mile away from where we were. And so many of the people at this thing were talking about access to case law as an access to justice issue. And there's all these other people meeting a few blocks away talking about access to justice and issues around that. And it just occurred to me that people don't kind of think about those things together very often. They don't think about how the lack of access to the fact that Thomson Reuters still owns a lot of the law and blocks, restricts access to it, or that other commercial publishers still claim ownership and copyright in the law, is a real access to justice issue, and one that should be talked about, I think, more openly and sort of maybe more collaboratively between the access to justice people and the access to law people. And so it was an interesting program.
Yeah, I thought your comments about the access to justice were really interesting. I mean, I just was sitting here thinking about it as I read it, and I was thinking, it's really funny. You have So you have a constitutional right to a lawyer in a criminal proceeding in this country, but you don't have a right to look at the law. Your only right is to work with a lawyer.
Right.
Weird.
Even lawyers can't get it.
Yeah. Only us lawyers. Sorry.
Yeah. They had the speaker, the keynote speaker at this thing was Carl Malamud, who, you know, the guy who's been kind of tilting at the windmills of opening up the law for years. And he's called for basically congressional legislation that would require all states and government entities of any kind to make digital versions of their laws, deposit them in the federal publication, I forget what they call the federal publication office or whatever, and make them available for free and in digital form to the public, which is an interesting
Wasn't
idea.
there some screwy case in Georgia a while back about this
that
whole
was him.
thing?
Just last
that was
year.
him.
Yeah, that's it. Yeah, okay. All right, good. I was wondering if that was the connection.
Public resource versus Georgia.
Yes.
Well, actually, a couple of years ago, I guess they got decided, but and that was something interesting. Is Malamud has still not been able to get those cases, even though he won in the Supreme Court. It wasn't cases; it was the statutes. But he's still apparently fighting with LexisNexis, who is the commercial publisher for those, to actually get those in some way. So weird. All right. Anything else we should talk about?
I had the MIT article, but I don't think there's time to go into it.
What was the MIT article?
Oh, it was it was an article about how the computer scientists really don't know how these large language models work, and it's really kind of appropriate with Niki's piece, because we're entering it. I mean, the thing that they were talking about in the article was the fact that these models can apply patterns to new situations. When you think about the mischief that could be done with that, particularly when it came to redacting articles, and the example they gave was a large language model could solve mathematical problems in English, but when it was shown French literature, it could then solve the mathematical problems in French, which is a leap. And the article was pointing out that the computer scientists aren't exactly sure, or maybe aren't sure at all, how these models are doing that, which gives you some pause when you think about you're going to trust these models to keep material confidential from your clients, and yet you don't exactly know how they're going to function, or if they could make a leap and do something new and different. So anyway, it was a pretty interesting article, even though I don't regularly read the Massachusetts Technology Review.
Well, that is interesting, and I think we've probably all at this point seen Pablo Arredondo talk about LLMs and all that. But that's the point he always makes, is that
He says the same thing.
Even the experts say this is a black box. We just don't really fully understand how it works, and it sort of seems to raise issues around a lawyer's duty of technology competence, which in part, if you look at some of the ethics opinion, would seem to suggest that lawyers, or at least experts retained by the lawyers, should be able to understand how technology is doing what it's doing and what the implications are for confidentiality and other issues.
And you think about the duties that were spelled out often in the cloud computing ethical opinions about how lawyers need to vet the provider. I mean, you start thinking, how are we going to vet some of these providers when even the provider isn't sure how these things are working? It just kind of raised a lot of concerns in my mind about what
I very
we're doing
recently saw an article about Stephen Hawkins, and before he died, his warnings about artificial intelligence and how it could be the end of the human race if it's not kept in check. And he said that it will take off on its own and redesign itself at an ever increasing rate, and that it could ultimately result in the end of mankind because it can match or surpass the intelligence of humans. And that's particularly alarming given the fact that we don't understand how these LLMs are working. So,
Oh.
you know,
I don't understand why you care. We're in a simulation, so like, what's your beef?
But
I know that's my only solace.
Dennis raised the point in the chat that lawyers don't understand how the cloud works either, which is true, but one of the differences is that somebody does.
Or why lightning doesn't interfere with it. I never understood that. All right. Well, Steve, I'm sorry I missed. I don't know why I missed that.
Well,
But
it may not have gotten in the spreadsheet because I was
it's
having
there.
trouble
It's
with
there. I
this.
see it now. I see it now.
Okay.
I don't know.
Oh, you were just ignoring me, Bob. I know.
I'm
I'm
just
used to it.
ignoring
It's
you,
okay.
No. All right. Well, I think that's it. We're about out of time. We're not about out of time. We are out of time. We're over time. So start paying time and a half to the panelists. So rather than do that, we are going to wrap this up right now. And hope everybody has a good week and see you all again next week.
Well,
And
Bye, everyone.